My name is Laura Wilson, Firm Administrator at Wilson Law Group. This is the third chapter in Trustee Orientation 101, the trust process entitled The Three-Step Strategy. The presenter of this program is Attorney Daniel Pertel, Principal at Wilson Law Group. Attorney Pertel is an estate planning law specialist and accredited estate planner, certified by the National Association of Estate Planners and Counsels and accredited by the American Bar Association. In this chapter, Dan will teach you about the foundational structure of trusts, what they are, how they work, and why they can be beneficial. Let's begin.
So what is a trust? A trust is basically a contract, and it has three players. We have the creator of the trust, and that is the person that did the planning on the front end. We have the trustee of the trust, and that is the person that manages assets. Then we have beneficiaries. So we have the person that makes the trust, the person that is going to be in control of the trust, and the person that is going to get the benefit of the trust assets. If you think about this, we have the husband and wife create the trust. They are going to wear all three hats. They are going to be the makers, the trustees, and the beneficiaries. That is how they continue to maintain control. They have not given up control of the assets. They have simply become the trustees of the trust that holds their assets. And then, of course, we can have situations where we have successor trustees stepping in the event that mom and dad, or husband and wife, or the creators of the trust have become incapacitated or then pass away. This is a visual that we like to use. This is a chest of drawers. The top drawer represents the revocable living trust while both spouses are alive. The middle drawers when one spouse is deceased, and the bottom drawers when both spouses are deceased. If we have an unmarried individual who has created the trust, we really just have the top drawer, and then we move down to the son and daughter level of drawers. All of our trusts have that top drawer, which means that while husband and wife or the individual are alive and well, they will open and close that drawer as they deem fit. That includes if they need assets, want to add assets, or take assets out of the trust, they are in full control. At that level, assets are likely going to be under the management of the trust makers or then the disability trustees. It is possible, as a successor, that you might need to step in to get access to that top drawer if the trust maker or trust makers are incapacitated. Upon the death of the first spouse, we are going to have a shift from one drawer to two drawers. Oftentimes, it will be a survivor's trust and a family or marital trust. The question mark on the family drawer notates that it depends on the overall circumstances if a marital or family trust will be used, but very likely the estate tax planning is done with a family trust. This is to use the estate planning exemption of the first spouse to pass. Each person has an estate tax exemption. That means that each of us can pass on to whoever we want the estate planning exemption without incurring any estate taxes. If we want to use the exemptions from both the husband and wife, we push the first spouse to die's share of the assets into the family trust. The reason there is a question mark is depending on the size of the estate and the plan, there could be a marital trust there. We make a flow chart that is specific to each trust plan that illustrates how this movement of assets will work for you. Almost every case will be managed by the surviving spouse, and he or she is the sole beneficiary, potentially with the children being the contingent beneficiaries of that family trust. Let's go to the third level. Eventually, we will have assets pass on to son and daughter or other beneficiaries. This could be in the example of the individual trust. We skip the middle level and go to the third, but if we have a married couple, we oftentimes have son and daughter receiving assets after both parents are deceased. They often don't receive assets outright. We are showing that they are receiving it in a drawer, which is actually their trust. We have assets in trust going to son. Oftentimes, son will be the trustee and beneficiary of his own trust. That gives him the ability and authority to manage the assets in the trust as he sees fit, and also have those assets protected from creditors and divorce. There are things that we are certainly cognizant of when we set up planning with our clients. The same is true of daughter. For example, Daughter has some addiction issues. She receives assets in trust, but she, because of her situation, might not be a good person to manage the trust. If you are a successor trustee, you might be the trustee managing the trust for daughter's benefit. Daughter is the beneficiary, but we don't want daughter to have the purse strings. We are concerned about what that would mean for the assets in the trust if she had access to them with no strings attached. Just like we talked about, we are not planning for just taxes. More and more of the planning we are doing is planning for protecting the surviving spouse. The family or marital trust can have built-in asset protection from a creditor for the surviving spouse. For example, the surviving spouse has a car accident after the death of the first spouse. The assets in the family or marital trust have a layer of creditor protection from a judgment creditor. Another issue that comes up is if the surviving spouse were to get remarried. If that is the case, what we have done in many circumstances is actually build in language that requires that the surviving spouse and that new spouse have a prenuptial agreement. This protects the assets of the first to die so they can't be reappointed to the new spouse. For children and even grandchildren, we really focus on the need to provide them with protection. We don't know if the children are going to have divorces, creditors, lifestyle issues, or special needs, but by planning and leaving assets in trust, we can actually protect against those issues. How do we know when we have a trust maker who is incapacitated? For those of you who are successor trustees, I would certainly recommend that you talk with your trust makers, not only about what their wishes are, but also about how the terms of their trust lays out. The trust is laid out by article and section. In most of the trusts that we have drafted, Article 4 is where you will find the process for determining the disability of a trustee or trust maker. Most likely, it will be the trust maker's primary doctor or attending physician and then the healthcare agent who would have to put their heads together and put something in writing or certification that says that the trust maker trustee is incapacitated and should be removed in favor of the remaining named trustees. The powers of the disability trustee are basically the same powers that the trust maker trustee had. Also, there are directions for the disability trustee as to the type of care that the trust maker wants to have with their resources. There are some bonus benefits of the living trust. You still maintain control of assets. If husband and wife set up a trust, they have not lost control because they are both the trustees and beneficiaries of their trust. If they want to take the house out of the trust and sell it, fine. If they want to put the proceeds into the bank account that is in the name of the trust, fine. If they want to take that money out to buy a new house, they can put the new house into the trust. They have not lost control of assets. They can change the trust. If they decide to disinherit a child or to change their charitable beneficiaries, those things can occur while they are both alive and well. We talked about death probate, but what is a living probate? You might have heard the term guardianship or guardian. If someone becomes incapacitated and they don't have planning in place with correct documents, it is very likely that those next people in line would have to go down to the court, ask to be appointed as guardian, and then have a guardianship proceeding. We avoid that because we have appointed healthcare agents and successor trustees. We will not have the need to have what is called a living probate. We talked about death probate in some detail, but what does it mean to avoid death probate in all states? We do have clients that have property in multiple states. Oftentimes it will be property in Wisconsin and another state. If I own property in my name in Wisconsin, and I also own property in my name in Florida, and then I pass away, I will have a probate in Wisconsin and a probate in Florida. We entirely avoid that by having assets all in the name of a trust. We don't have a probate in Wisconsin, and we don't have a probate in Florida. There is no probate. It is hard to understate the importance of privacy as it relates to a living trust. We talked about probate. We really didn't talk much about the fact that there are privacy concerns our clients bring up on a regular basis. Probate is a court process, so it is an open records process. That means that if someone wants to go to the courthouse into the probate office and open any file that is there, they can do it. That file says who the beneficiaries are, the inventory of assets, valuation of assets, and who the creditors of the estate are. There is a lot of information in that file that I would definitely not want to have made public. By having a trust, we avoid probate. The only people that are going to be privy to the administration of that trust are the named trustees and beneficiaries. There is no way for a third party to force their way into finding what is happening in the trust-based plan, so privacy is at a premium. This minimizes the possibility of potential contests. How does a trust do that? First, by avoiding probate, we are going to avoid that court process. If there is one thing we know about court, it is that people can hire attorneys, make objections, and try to cause trouble by pushing themselves into the court proceeding. By avoiding probate, we avoid that entirely. The other reason that a trust helps avoid contests is that we oftentimes put a no contest clause into the trust. This essentially says if you challenge what our wishes are as a beneficiary, your share or what you are supposed to receive is taken away. It is really a take what you get and keep your mouth shut provision. Finally, a trust is contract law. There is a principle in the law in which the longer a contract is in force and being used, it gains strength. I have been told that anywhere between 7 to 10 years is that time frame. The longer we go out from that time from creating that trust and putting assets into it, the more strength the trust has. It is very, very difficult to challenge a well-drafted trust. The term funding, as it relates to trust planning, deals with how assets are coordinated with the trust. Assets like real estate, bank accounts, stocks, bonds, and all property that is not beneficiary designated will be retitled into the trust. So we create the trust, we put the house, bank accounts, stocks, bonds, and personal property into the name of the trust, and that is how we avoid probate. So if we don't own assets in our name, there is nothing to probate. It all passes by the terms of the trust. The other assets that you don't see here would be things like IRAs, retirement accounts, life insurance, and annuities, particularly qualified annuities. Those will pass through the trust by beneficiary designation. Also, it is very important to make sure that those are correct and coordinated because we are seeing more and more clients with that type of asset, particularly the retirement account assets.
This ends the third chapter in Trustee Orientation 101, the trust process. If you have any questions about the information covered in this chapter, please contact the trust maker, your attorney, or call or email our office. Attorney Pertel will continue this discussion of the trust process in the fourth chapter entitled The Three-Step Strategy. Thank you for listening.